Hello everybody, Don Rolfe here, owner of Northwest Legal Planning, estate planning and probate law firm in West Linn, Oregon, and I'm here to talk to you today about whether or not your power of attorney is expired or whether it's still operative, whether it'll work when you need it. If you have any questions about this or any other estate planning topic, do feel free to reach out to me absolutely free by going to myestateplanmeeting.com and scheduling an appointment either on the phone or in person. So is your power of attorney going to work when you need it? Is it still operative? So the first thing we need to know is what type of estate plan do you have and what type of power of attorney do you have? Generally, if you have a trust-based estate plan, you're not going to be relying upon your power of attorney for many things because you're going to be transferring your assets into your trust. So if something were to happen to you, then your successor trustee will be able to manage those assets. The only types of assets that we're not going to be able to do with the trust are going to be assets that have to remain in your own name. So if you have retirement accounts, power of attorney will be necessary for your successor to be able to talk to the plan administrator and to be able to make those withdrawals or change the withdrawals that are being made. A power of attorney is going to be necessary. And if you have a will-based estate plan and you become incapacitated and the power of attorney becomes necessary, then it's going to be for pretty much everything. Anything that your agent under the power of attorney is going to need to do will have to be through that power of attorney because things aren't transferred into a separate entity, such as a trust, where your successor can just take over as the manager of those assets. So it's important to know that if you have a will-based plan, your power of attorney is generally much more important. And the two types of powers of attorney that we have is just a general power of attorney. Obviously, there are more types. There are powers of attorney for specific instances and those sorts of things, but I'm going to talk generally. We have a general power of attorney, and then we have a durable general power of attorney. So a regular non-durable power of attorney will cease to operate once you become incapacitated. So if you're no longer able to do actions, then your agent under the power of attorney is no longer able to do actions. Conversely, a durable power of attorney means that it stays into effect and your agent is able to continue acting even if you are unable to act. So if you become incapacitated and you have a durable power of attorney, your agent is going to continue to be able to act on your behalf. So most always I prepare a durable power of attorney for my clients so that there is that ability if the client becomes incapacitated for their agent to act if necessary. So when do powers of attorney, whether they're durable or non-durable, when do they expire? When do they stop working? When you pass away, your power of attorney is gone. Whether it's durable or not, your agent is no longer able to operate under that power of attorney. There could also be a term inside of your power of attorney that says that it expires on a certain date or when a certain event happens. So if you're married, it could say in your power of attorney that it's good until such time as I get divorced or there's an annulment. Or it could be that it's just for a certain period of time. You know, this power of attorney is good for 5 years from the date it was signed. That's not as likely, or it's good until it's revoked. Those are all things that are inside of the document that or under the law that say when a power of attorney is no longer operative. However, it's also the case that your power of attorney is no longer operative if the third party that it's being presented to decides not to accept it. So if your agent goes to the bank to make a withdrawal on your behalf, when you've become incapacitated and the bank says, we're not going to accept this power of attorney, we think it's too old, we think it's stale, which is something that we hear from banks sometimes. They don't really go stale. You know, it was signed more than a year ago. There's no law that says it has to be signed within a year of trying to use it. But the third party, they're under no obligation under the laws to accept a power of attorney. They can always refuse to accept it. And at that point, if you were incapacitated, your family or your agent or whomever it is that's trying to look out for your best interests would have to go to court and have someone appointed to manage your affairs for you. So how do we get around this? Well, I almost always want my clients to set up a trust because it just makes things a lot more streamlined and allows for much more flexibility and more assurances that we're not going to have problems when dealing with third parties. However, I also set up will plans. And for will plans, I am extremely emphatic that my clients make sure that they submit a copy of their power of attorney to all of the financial institutions that their agent may, at some point down the road, have to transact business with on my client's behalf. And this way, that power of attorney is on file right away with the bank or the financial advisor or the insurance company or whomever it is, so that that company has already accepted that power of attorney, or maybe they've accepted it plus had you sign a copy of their form of power of attorney. And if they're doing that, make sure that that form of power of attorney doesn't revoke the one that we did together. But make sure that those things are online or with those institutions so that they already have them in their systems and there's not going to be a question when your agent goes in to act on your behalf. So again, it's really important to know what type of estate plan you have so you can tell whether or not your power of attorney is going to be used primarily during your incapacity or whether it's not going to be used as the primary tool. And then it's also important to know whether or not your power of attorney is durable or not durable, because if it's not durable, then you become incapacitated and your agent is not going to be able to act on your behalf because you can't act on your behalf. And then finally, if you're going to be relying on that power of attorney, get it to those third parties as soon as you can to make sure that they understand that you've executed this power of attorney, you want it to be operative. All right. If you have any questions about this or any other estate planning topic, do feel free to reach out to me. You can go to myestateplanmeeting.com and schedule a complimentary telephone call or in-person meeting. I will answer any of your estate planning questions and then also give you guidance on what my recommendation would be for you going forward putting together an estate plan. Again, I am Don Rolfe, and I look forward to talking to you soon. Take care. Bye.